In this lesson, we're going to go over the most frequently tested and highest yielding areas of criminal law on the bar exam, or in other words, we're going to go over the absolute must-know stuff in criminal law for the bar exam, which historically, if we look at the data, is going to be homicide, property offenses, burglary, criminal capacity, and some of the defenses. These are the areas typically where we're going to have the most opportunities to collect points on the bar exam. So these are the areas and concepts I'm really going to try to break down as best as I possibly can over the next 60 minutes or so. But with that, we can just jump into it. I'll set the timer over here to 1 hour. Ready, set, go. So the clock has officially started. We can just jump right into criminal law. So one of the cool things about criminal law as a bar exam subject is most of the analyses are very elemental, right? We're just applying the elements of the crime to the fact pattern to determine whether or not the defendant is liable. And at its core, we'll find that almost all the crimes we're going to talk about have two essential elements, right? And you probably remember these from law school. We have number one, the Actus Reus requirement, and number two, we have the mens rea requirement. We'll see that to hold a defendant liable for almost any crime we're going to talk about, at its core, these two elements are going to have to be satisfied. The Actus Reus just refers to the idea that we either need a voluntary physical act or an inaction where there's a legal duty to act that is known to the defendant. But for our purposes on the bar exam, what we're normally looking for here, and all of the crimes we're going to talk about in this lesson really deal with voluntary, right, physical acts. So something we'd want to look out for here on the bar exams, anytime that we're seeing a fact pattern where the defendant has some sort of involuntary bodily movements that result in harm. Imagine that a person is driving down the road and they believe themselves to be a perfectly healthy individual, and out of nowhere, right, they start to have some sort of seizure or heart attack, and they start convulsing, right, and lose control of the car and crash into a pedestrian, and the pedestrian dies upon impact. Of course, our question will be, is that driver potentially liable for criminal homicide, some form of murder or manslaughter? And our answer is going to be no. If the actions that led up to the death of the pedestrian were all involuntary bodily movements, right, then the defendant is not going to be able to will not be able to be held liable for murder or manslaughter because there were no voluntary physical acts, right? The Actus Reus will not be satisfied. So with most of the crimes we're going to talk about today, we'll see the Actus Reus requirement is usually pretty easily satisfied, right? Most of the time, if you're going to go steal something, or you're going to go murder somebody, or right, any of these crimes that we're really going to talk about, you're going to go burglarize a property, usually, right, we're dealing with voluntary physical actions. A person isn't going to have convulsions and involuntarily steal somebody's property, right? That's typically not what we're going to see with Actus Reus, but is something to keep in mind, right? If we do see a fact pattern where there does appear to be involuntary bodily actions, right, we want to keep that in mind. And do also remember that there is that idea too of a possibility if we have inaction where a legal duty is owed and the defendant fails to act and knows that they had a duty to act, right, that could also satisfy the Actus Reus requirement without a voluntary physical action. Next though, and what we're going to spend a lot of time kind of discussing as we work through all these different crimes, is the mens rea requirement. Right, almost all crimes are going to require that at the time that the Actus Reus is occurring, that the defendant is going to have a culpable mental state, right? So when the voluntary physical actions are occurring that constitute the crime, we say that the defendant must at that same time have a culpable state of mind, right? And what level is required to have a culpable state of mind is going to depend on the type of crime that we're dealing with, right? We'll see at common law, there's really 4 types here. We have number 1, specific intent crimes. Specific intent crimes. Number 2, we have general intent crimes. Number 3, we have malice crimes. And number 4, we have strict liability crimes. At common law, these are kind of our 4 categories of crimes. Important to recognize that today, under the Model Penal Code and in other jurisdictions, right, these distinctions have been done away with to a large degree, right? But for our purposes on the bar exam, we're always in criminal law applying the common law unless we are told otherwise, right? The common law is our starting point. If the bar examiners give us some sort of statutory modification in the fact pattern, then of course we do what the bar examiners tell us to do. We apply the law that we're told to apply. But at default, right, we're always applying the common law in criminal law. So that's what we're really going to focus on heavily in this lesson. And again, at common law, there's really 4 categories of crimes when we're thinking about mens rea and the mental state requirements, right? We have specific intent crimes, general intent crimes, malice crimes, and strict liability crimes. So we can quickly kind of talk about the differences between each one of these and then give a few examples, right? So specific intent crimes would be the types of crimes where the defendant must intend to commit, right? For the defendant to be liable for a specific intent crime, the defendant must have intended some criminal objective or some specific criminal intent, right? So classically for specific intent crimes, we'll see our property offenses are specific intent crimes, and maybe even premeditated intent to kill when we talk about that could be a specific intent crime. But think about the property offenses, right? All of these property offenses we see up on the board here: larceny, false pretenses, larceny by trick, embezzlement, robbery. We'll see all of these are specific intent crimes. And really at their core, they have the same specific intent requirement, right? The idea is the defendant to be held liable for any of these types of property offenses needs to have the specific intent to steal, right? To permanently deprive another of their property. If that is missing, that specific intent to steal, right? If the defendant doesn't have that specific intent to steal, we'll see that the defendant cannot be held liable for any of these crimes, right? They need that specific intent. So if they think they're just borrowing something, or if they think they're retrieving their own property, right, then they don't have that specific intent to steal, that specific criminal objective. So we're going to see that they're not liable for those property offenses, right? General intent is very different, right? General intent is far more broad. It's more of a catch-all type of intent. With general intent crimes, and these would usually be crimes that involve a harm to a person outside of common law murder. So things like battery, false imprisonment, kidnapping, all are going to be general intent crimes. And we'll see with general intent crimes, it's not necessarily whether the defendant intended any criminal objective or any particular outcome. It's really just about whether the defendant intended to commit the unlawful act. So think about a battery, right? Unlawful application of force to another person that results in some type of harm or offensive bodily contact, right? So imagine that you have 2 buddies that are at a football game and something exciting happens and one of the buddies kind of punches his friend's arm out of excitement, like, hey, can you believe that just happened, man? And out of the excitement and in the moment, he kind of punches his friend in the shoulder, meaning it to be a form of kind of camaraderie and excitement, but maybe he does it a little bit too hard, right? And say when he punches his friend's arm, it actually breaks his friend's arm, right? The shoulder, snaps or whatever. We have significant damage to the arm. And the idea is, can that friend, that defendant, be held liable for the battery? For our purposes, right, does he have the mens rea requirement needed to be held liable for that battery? Well, battery is a general intent crime. So we know general intent crimes, it's not about whether the defendant intended to break this guy's arm or not, right? Or what level of harm he meant to cause. Whether he meant to cause a light bruise or, break this guy's arm or really not cause any harm at all. All of that's irrelevant. All we care about for a general intent crime is whether the defendant intended to cause or commit the unlawful act. So just that unlawful act of the unconsensual harmful contact, right? Did the defendant intend to cause that or commit that unlawful act? And from that conduct, we could probably infer that, right? When the defendant's reaching out with his arm and hitting his buddy's arm, right, without consent, right, we can see how that defendant did intend to commit the unlawful act, that that unconsensual physical contact that results in harm that would be needed for the battery. Right, so we see with general intent, the defendant can't say, oh, I didn't mean to break his arm, that wasn't my intention at all. Right, that's not a valid defense. That won't negate the mental state requirement for battery, because battery is a general intent crime. All we care about is whether the defendant actually intended to commit the unlawful act. Right, that unlawful physical contact. And that would be easy to show in that example. Right, next we have malice crimes. Malice crimes you can think of as just like a reckless disregard. It's kind of like a criminal form of negligence, right? Maybe you didn't intend any specific criminal objective. Maybe you didn't even intend necessarily to commit an unlawful act, but your conduct was such a reckless disregard. The way in which you acted was in such a way that was a complete reckless disregard to an obvious risk that it could result in harm to another person, right? This would be like, you walk into a crowded room with a gun and shoot the gun into the air, right? And the bullet bounces off the wall, ricochets, and hits somebody and kills them, right? Sure, maybe you didn't have the specific intent to kill somebody, but we would say that's a complete reckless disregard, to an unjustifiably high risk to human life, right? You're taking, that we would say is clear malice, right? Even though you maybe didn't have the specific intent to kill anyone or the specific intent to harm anyone, right? That's just a very gross, high level of criminal negligence and complete reckless disregard to an unjustifiably high risk to human life, right? And we'll talk about kind of the different levels of malice as we work through these crimes. Strict liability crimes is unique in that really all that's required to hold the defendant liable for a strict liability crime is that the actus reus is satisfied. If the actus reus is satisfied, right, a defendant can be held liable for a strict liability crime, right? This would be things like selling liquor to underage kids, right? Selling liquor to minors, or statutory rape, right? In these cases, there is no mental state requirement for strict liability crimes. All that has to be shown to hold a defendant liable for a strict liability crime is that the actus reus was satisfied, right? So with this, important to note that any defenses that can be used to negate the mental state requirement do not apply to strict liability crimes. So like a mistake of fact defense could not be applied to a strict liability crime. Saying, oh, I didn't know this person was underage when I sold them this liquor cannot be a defense for a strict liability crime. All we care about is that you voluntarily did sell it. You committed the actus reus, right? You voluntarily handed over that liquor in exchange for money. As long as you satisfy the voluntary physical act requirement that constitutes the crime, right? You satisfy that actus reus requirement. We don't really care for strict liability crimes what your mental state was, what your actual intent was. Now, in the bar exam, right, we're normally not dealing with strict liability crimes, right? We're usually dealing with either specific intent crimes, general intent crimes, or malice crimes. So these are the ones we're really going to focus on, but important to recognize that strict liability crimes do exist, and we can't apply any defenses that negate mental state requirements to strict liability crimes, right? And in that same vein, another important note to make is some defenses we'll see are only valid for specific intent crimes, and some defenses kind of have to be modified in the way that we apply them for general intent crimes and malice crimes. So below the video, it will be important to take a moment and really memorize, okay, what are the specific intent crimes? Memorize that list. What are the general intent crimes? Memorize that list, right? What are the malice crimes? Memorize that list. It's actually pretty easy. It should only take you a few minutes to do that, but you want to know what the specific intent crimes are, what the general intent crimes are, what the malice crimes are. That should just be something that you have committed to memory, because it can be important when we're applying defenses, right? We'll see that the way in which we apply defenses really can depend on what type of crime it is, right? So that'll just be something below the video to memorize. But with that, that's pretty much everything we need to cover with the essential elements and kind of the mental state requirements from a big picture standpoint. So one other note to make here is don't get too tripped up in any of this. If this seems a little bit confusing, you maybe aren't fully confident with these different intent requirements, right? The key is, as long as you know how to apply the elements of these crimes properly, which we're going to work through some examples here, then you know how to do this actus reus and this mens rea thing as you're applying the elements, right? The actus reus requirements and the mens rea requirements are baked into the elements of these crimes. So if you're working through the elements and you're applying the elements of these crimes correctly, right, then you're doing the actus reus and mens rea analysis correctly as well. In other words, right, if you're on a criminal law essay, you don't necessarily have to keep working through actus reus and mens rea in your analyses, right? You're doing that automatically as you work through the elements. Now, of course, if the call of the question asks you something about actus reus or mens rea, you need to know what that means and you need to be able to respond to that. But otherwise, if you just work through the elements, you're usually working through these requirements, right? They're baked in to the elements of the crimes, right? But with that, we can jump right into homicide. So the cool thing about criminal homicide is on a criminal law fact pattern, these fact patterns are usually pretty easy to issue spot from a big picture, right? Anytime on a criminal law fact pattern, we see that we have a person dying, right? One human being is doing something and it results in the death of another human being, right? We're always thinking criminal homicide. Important to note that if we see the death of a pet, right? A dog, a cat, albeit sad, right? It's not homicide. We need the death of a human being. And to hold somebody liable for criminal homicide, we need to show that the defendant, right? Defendant is the actual and proximate cause of the victim's death, right? And we can put this in kind of question format, help us out here, right? So anytime, again, that we see a fact pattern where a person is dying in criminal law, right? And it looks like we might have one human being killing another human being, I would kind of always start with causation. Just really quickly run through this. Sometimes it's absolutely not an issue, right? If you see a defendant walk up to a person, right, with a gun and point the gun right at the person's head and pull the trigger, and that person dies as soon as the trigger is pulled, right, and the bullet goes through them, right? Well then, yeah, of course the defendant in that case is the actual and proximate cause of the victim's death. There's no issue of causation there. But sometimes we'll see it's not always that straightforward, right? From the time that the defendant's conduct begins until the victim dies, things can happen in the timeline that make this a little bit murkier. But this is usually where I would kind of just start, right? And if we find that the answer to this question is yes, right? If the answer to this is yes, the defendant is the actual and proximate cause of the victim's death, then at common law, there's really three options, right? At common law, absent some defense that we can talk about later, there's really three options, right? At common law, that means the defendant is either going to be liable for murder, right, voluntary manslaughter, or involuntary manslaughter, right? We basically have three options at common law. Now we'll see there's some statutory modifications with first and second degree murder. We'll get there later. But at common law, right, there's really three options. If the defendant is the actual and proximate cause of the victim's death, it's either going to be murder, voluntary manslaughter, or involuntary manslaughter. And this is in descending order of seriousness, right? Murder being kind of our most serious offense at common law, involuntary manslaughter being our least serious offense, voluntary manslaughter falling in the middle. Now, of course, if we find that the defendant is not the actual and proximate cause of the victim's death, right, is not the actual and proximate cause of the victim's death, then we would just say the defendant is not liable, right, for criminal homicide, right? So the defendant cannot be liable for murder, voluntary manslaughter, or involuntary manslaughter if the defendant is not the actual and proximate cause of the victim's death. So what do we mean by actual cause and proximate cause? Right, if you've watched our torts video in this series, you probably have a good idea, right? It's the same, it's a very similar analysis, right? Actual cause, right, really just means but for cause. It requires us to look at this and say, okay, but for the defendant's conduct, would this victim still be alive? If the victim would be alive but for the defendant's conduct, right, then we know the defendant is the actual cause of the victim's death, right? Proximate cause is all about the chain of liability and whether anything bizarre, abnormal, or completely unforeseeable has happened from the time the defendant's conduct occurred until the victim's death that could cut off the chain of liability. So proximate cause, we always want to think about in terms of a timeline, right? Which we can just draw up. So typically in the fact pattern, right, it's going to be like this, especially in a criminal law fact pattern, it'll look like this, right? The defendant's going to do something, right? We're going to have defendant's conduct. That's kind of our start. Then things might happen, and then we're going to have the victim's, right, death. Right, so again, sometimes this can be bang bang, right? There's really nothing that happens in the timeline, right? Defendant goes up, shoots somebody in the head with a gun, and the victim immediately dies. Okay, right, then there's no proximate cause issue, there's no actual cause issue. D is the actual and proximate cause of the victim's death, right? What we're concerned about here is if things happen from the time the defendant's conduct is happening until the victim's death. Oftentimes what you'll see is the defendant does something, it causes some harm to the victim, then the victim's being transported to the hospital for treatment, and something else happens that ultimately causes the victim's death. And the question is going to be whether the defendant is liable for the victim's death, right? For either murder, voluntary manslaughter, or involuntary manslaughter, right? And so what we always want to do is ask, okay, is this event that happened something that's abnormal, bizarre, or completely unforeseeable? If so, it's going to break off the defendant's liability. So imagine that the defendant shoots the victim in the leg, right? Wounding the victim. So an ambulance comes and picks the victim up. As the victim is being transported to the hospital in the ambulance, let's say a meteorite, right, comes crashing from the sky and hits the ambulance, right? And upon impact, the meteorite kills the victim, right? The question is going to be, well, is the defendant liable for the victim's death, right? Is the defendant criminally liable for that homicide if the meteorite crashes into the ambulance, killing the victim? And the answer is going to be no, right? Here, although the defendant's conduct would be the actual cause of the victim's death, right? We could say here that but for the defendant's conduct, right, this victim would still be alive, right? If the defendant had never shot this victim in the leg, they would have never been in that ambulance, they would have never been hit by the meteorite, they would not be dead, right? But for the defendant's conduct. Therefore, the defendant is the actual cause of the victim's death, but where we're going to have an issue is something bizarre has happened here. Something abnormal has happened. Something completely unforeseeable has happened in our timeline, right? The defendant shot the victim in the leg as he's being transported. A meteorite comes crashing down, killing the victim, right? In that case, we're going to say when that meteorite struck the victim, the chain of liability was cut at that moment, right? The defendant's not going to be liable for anything that happens to the victim after that point, right? In terms of the harm to the victim. Okay, so that's the main thing with causation we want to look out for, right? Things that would not be considered abnormal or bizarre. And the reason I'm using these words, abnormal and bizarre, right? Abnormal and bizarre, abnormal, and bizarre, is because this is the exact language that the bar examiners have used, right? When we look at the explanations that they give to us for their prior questions, they cite a case and that talks about abnormal and bizarre events happening. So I think this is a good buzzword to use. Also, though, just the idea is if it's unforeseeable, right? or abnormal or bizarre, like a meteorite falling from the sky. Things that would not be considered abnormal or bizarre or unforeseeable would be things like negligent medical care from a third party, right? The doctor messes up the surgery. That's not abnormal or bizarre, right? That results in the victim's death, right? The doctor does something wrong and that causes the victim to die. We would say that's foreseeable, right? The defendant's still on the hook for homicide if that happens, right? If the victim refuses medical care for religious reasons, right? We know that's the victim's constitutional right. That's not abnormal. A person exercising their constitutional rights are not abnormal or bizarre. That would not break the chain of liability, right? Just the ambulance getting into a car accident, right? The ambulance is transporting the victim to the hospital and they get hit by an 18-wheeler, right? That would not be abnormal or bizarre. Car accidents happen all the time. That's foreseeable, right? We need something really abnormal. Think like a meteorite falling from the sky, something completely just unanticipated happening, right? That could break the chain of liability. Okay, but we need to move on. This is step one, though, I would think, when you're looking at a fact pattern. You're trying to determine whether the defendant is liable for some form of criminal homicide. At common law, murder, voluntary manslaughter, or involuntary manslaughter, we always want to ask, is the defendant the actual and proximate cause of the victim's death? If so, remember, we have three categories over here, right? At common law, that means unless a defense is going to be applied, if the defendant is the actual and proximate cause of the victim's death, unless a defense applies, right, we are pretty confident that the defendant's going to be liable at common law for either murder, voluntary manslaughter, or involuntary manslaughter. So the question becomes, how do we distinguish between these three? Well, we can start with murder, right? Murder at common law is the killing of a human being with malice aforethought, right? So at common law, murder is the killing of a human being with malice aforethought. And we get malice aforethought if the killing is committed with certain mental states in mind. There's really four we want to think of, right? Number one, we have the intent to kill. Number two, we have the intent to inflict great bodily harm. Number three, we have reckless indifference. Reckless indifference to an unjustifiably high risk to human life. Sometimes we call this depraved heart murder, right? And number four, we just have the idea of felony murder, right? The intent to commit an inherently dangerous felony, right? So if any of these mental state requirements are met, right? The killing is committed with the intent to kill. The defendant kills another with the intent to inflict great bodily harm. The defendant is acting with a reckless indifference to an unjustifiably high risk to human life that results in the death or the killing of another human being, right? Or if we see the defendant killing another human being with the intent to commit an inherently dangerous felony, any of these, we're going to say that's common law murder, right? That's the killing of a human being with malice aforethought. Any of these mental states give us malice aforethought at common law, right? So we'll really want to break those down. Voluntary manslaughter is really just heat of passion, right? Adequate provocation, right? Adequate provocation or heat of passion killings. So this is where we say voluntary manslaughter is essentially murder, but for adequate provocation, right? So we'll talk about what adequate provocation is. And involuntary manslaughter is an unintentional killing, right? Unintentional, right, killing with either criminal negligence or during an unlawful act that falls outside the felony murder rule. Right, but this is kind of big picture. We can just jump right into common law murder, right? The killing of another human being with malice aforethought, right? So the real question is, well, what is malice aforethought? Number one, if the killing occurs, the defendant kills another human being with the intent to kill, right? That's malice aforethought, easy common law murder. This would be the classic, I go up, right? Defendant goes up to somebody with a gun, points it at their head with the intent to kill them, pulls the trigger and kills them, right? Obvious common law murder, intent to kill. Intent to inflict great bodily harm would be very similar, right? Defendant goes up to the victim with a gun and with the intent to cause great bodily harm starts shooting them multiple times in the leg, right? But clips the femoral artery, that person bleeds out and dies, right? That would be malice aforethought, right? We'd say that's common law murder, right? Those two are very easy to see most of the time. The more interesting analyses are usually depraved heart murder, this idea of reckless indifference to an unjustifiably high risk to human life, and this intent to commit an inherently dangerous felony. So reckless indifference, right, or depraved heart murder, when we're thinking about this in terms of common law murder, the killing of another human being with malice aforethought, means that the defendant has done something, right, so devoid of social utility, right? It's so reckless. It's a complete reckless indifference to an unjustifiably high risk to human life, that even though they didn't have necessarily an intent to kill anyone, an intent to inflict great bodily harm, maybe they didn't even have an intent to harm anyone, but we don't care because this activity was so reckless, right? The just complete reckless indifference to an unjustifiably high risk to human life, we're still going to hold them liable for depraved heart murder, right? The classic example of this would be walking into a crowded room with a loaded gun, pointing the gun up in the air and pulling the trigger, right? Say that the bullet ricochets off the ceiling, hits somebody and kills them. Well, sure, the defendant may not have had an actual specific intent to kill anyone, right? They may have just been shooting the gun up for fun, like as a joke or something, or to get attention, right? They just shoot a gun up into the air. They don't have an intent to kill anyone. They don't have an intent to harm anyone either, right? But here we would say, who cares, right? Even if you don't have an intent to kill anyone, even if you don't have an intent to harm anyone, that's complete reckless indifference to an unjustifiably high risk to human life, right? You can't go into crowded rooms and shoot guns around, right? That's just completely devoid of any social utility. For that reason, right, that type of reckless indifference to an unjustifiably high risk to human life, we call depraved heart murder, right? We're going to say that's the killing of another human being with malice aforethought, even though you maybe lacked an intent to kill or an intent to inflict great bodily harm. It's too reckless, right? It still rises to the level of killing of the another human being with malice aforethought, right? Typically, what you find with depraved heart murder on bar exam fact patterns is anytime someone's using a weapon, right? Some object that's really been designed to kill or maim people, right? Think about using a sword, an axe, a gun, a rifle, right? Some sort of poison, right? Anything that's kind of in a way been designed to like cause harm to people. If you're doing reckless stuff with these types of objects and it results in someone dying, a lot of times we get to depraved heart murder. Imagine somebody goes out to a public park with a bow and arrow, right? And wants to work on their archery skills. So they set up a bunch of targets at the public park. Of course, they miss one of the targets and an arrow goes into somebody, killing them, right? That would be reckless indifference to an unjustifiably high risk to human life. Even though they didn't have the intent to kill or the intent to inflict great bodily harm, it's still murder, right? That's a killing of another human being with malice aforethought, depraved heart murder. Right, finally, we get to intent to commit an inherently dangerous felony. Thank you so much for watching this video preview of our Bar Blitz video series. If you would like to see the conclusion of this video and gain full access to our entire Bar Blitz video library, which includes coverage of the most frequently tested and highest yielding areas of law in each bar exam subject, we invite you to head over to our website and join the thousands of law students who have already enrolled in Studicata Bar Review. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com.